Okay, so as Thad mentioned, I'm going to basically run through the federal rules and orders that are applicable to Zoom depositions that you may need to argue, or you may need to defend against, or whatever your position is in the particular litigation. We currently have, a number of cases that this is relevant to. I think when COVID first started, I was kind of naive and thought, oh, we're going to get a month off from court, basically, and then this will all resolve. So everybody put in their extension motions. Everybody agreed to various extensions just for this issue to resolve, because the natural bias is for live depositions. That's the way I was brought up, and that's been the practice in the past. And you've got older lawyers who, everybody has the feeling that the drama is in the live deposition. But recently we have, we put in for another extension in our Arizona case, and the judge wrote back and said, hey, guys, tell me what's going on. What do you specifically need? What's left to be done? What can be done remotely? I need to know, because this is basically the fourth extension. We have another case. We hadn't yet started discovery. It's up in Illinois. So that's kind of been a hot spot historically. And the courts there are saying, it's not really clear that this will resolve quickly. So, let's get moving. So I went ahead and proactively wrote to the other side and said, what's your position on Zoom depositions? Because if we need to get before the court, knowing what I know now, let's go ahead and get it resolved. So basically I will be addressing three questions. One, can a party obtain a remote deposition even if the opposing party is objecting or simply refusing to attend or refusing to even download the Zoom platform? Two, if a party can get the remote deposition authorized, what are your rules of engagement going to be? And then finally, what are the rules governing the recording of remote depositions? And can you use the platform like Zoom to record your deposition? Would that be authorized by court? So we start with the overarching statute is the CARES Act. I don't know if you looked at it recently or ever, but there is a provision that says the judiciary, if they find that these emergency circumstances caused by COVID is delaying proceedings or causing issues, or there's a health risk to having live proceedings, that video is authorized, teleconferencing authorized, basically everything to get cases moving in the criminal context. Now from that, the executive committee of the judicial conference said, well, we've also got civil proceedings that we don't want endlessly delayed either. So they, the judicial conference authorized exception to the cameras in court rule. Typically, if you've been in federal court, you know that they don't allow cameras to broadcast out the proceedings. That's been taken away so that the public and the media can access proceedings. So you have a good kind of foundation for arguing that, hey, this works for federal courts, this works for criminal courts, where someone's liberty is on the line. Video depositions are not that far off if this is all authorized in live judicial proceedings. So you've got kind of the framework that starts there. Then you can move to the federal rules of civil procedure. Thad's favorite rule is number 1, which says everything should be interpreted to the just, speedy, and inexpensive resolution of cases, basically. So you start obviously with that and you say the justice delayed is justice denied. This is an inexpensive option. It's going to be faster than waiting months for this to resolve. And it's more fair to the parties because, we've got vulnerable populations. A lot of lawyers are older. A lot of witnesses are older. So are you really going to put them at risk, to take your deposition live? Federal Rule of Civil Procedure 30 allows for remote depositions by party stipulation. Obviously, when I reached out to counsel in Illinois and I said, how do you guys feel about Zoom depositions? If they said, we've got no problem, let's do them by Zoom, then we've got half the battle's over, because we now move on to kind of deciding how we're going to proceed on Zoom. But if your party If the other party says no, absolutely not, then you need to go to court and get an order to move forward with those. And I'll go through the case law and what your chances of success will be. And then next is Federal Rule of Civil Procedure 28, which specifies that depositions have to have an officer duly authorized to administer oaths present at the deposition. So that, you know, obviously you can't just set up a Zoom conference and have no third party who can swear the witness, and we'll kind of get into what that's going to mean for you moving forward. Okay. Then there are court standing orders. I don't know if you're on the automatic notifications for various courthouses. Thad and I are, and when this started, we were getting boom, 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 boom. Everything continued, everything moved, court suspended, blah, blah, blah. So every court basically had to come out with some procedure to handle these, the COVID pandemic. So Illinois Northern District, we have a settlement conference coming up that's going to be done via Zoom with a magistrate judge. They have authorized settlement conference, civil hearings, and bench trials, all to be done by remote means. The Washington Western District has said, we're going to have no live proceedings until September 8th. We're going to re-examine the issue. And in that instance, still do very, very limited live events. So we may allow some bench trials to move forward. Thad and I have a case in the Washington Western District right now. They told us we're not setting any jury trials before January of 2021. And we're currently on the docket for May 2021, kind of hoping for the best there. Now, if your defendant throws up a slew of objections to proceeding via Zoom, I would go straight to the In re Broiler Chicken antitrust litigation case. This defendant raised objection after objection after objection when plaintiff tried to move forward with Zoom depositions. They said, for instance, we have older witnesses and they don't understand technology. We have limited bandwidth at many of our witnesses' homes. Frankly, it's not fair to us that we should have to prepare our witnesses remotely either, and we can't travel to see our witnesses. And the court rejected all of those. The court said, get more bandwidth for your witnesses, work with them to improve their internet. The judge even said, I'm looking at some of these witnesses, and one of these was like the CEO of a large international chicken company, and you're trying to say because he's older, he doesn't know how to use technology. I mean, just any objection you could kind of think of is largely addressed by this case and rejected. So it's a good place to start. And then separately, these are my right slides. Defense have argued that it's prejudicial to us to have to do a remote prep, and that's been considered and specifically rejected by the Southern District of California, where they said, this is everybody has to adapt to a new way. We understand you have a lot of exhibits, but it's not unworkable, and we don't find prejudice, because when a plaintiff notices a deposition remotely and the other side opposes it, you start by showing what the good cause for asking this remote deposition is. And COVID has been found over and over and over again to be a good cause for that. Good cause for taking a remote deposition. And then the defendants or whoever's opposing it has to show what the prejudice is. So when they throw up a bunch of different excuses, basically the court saying, you're not showing me prejudice. Like, remote depositions have been found to be just as effective. You can observe the witness live still. In some ways it's better. So, you've got a lot of case law on your side when you're looking to do a remote deposition. Hold on just a second. Hey, Thad, do you have the other slideshow. This is not the one. Can you upload the other one? I can't hear you. I think you're muted.
Yes, thank you. Yeah, it'll take me a second. You can hear me now?
Yes.
Okay, let's see. So for everybody, what I'm doing now is because of a technical glitch, I will now try to load up a second half of this, the second half of Stephanie's presentation, because it was broken into two parts. And if I'm able to do that, we'll just see how long it takes. No, I just loaded one, but it was the wrong one. So let me, all right, we'll see this one. All right. Now what I'm going to do is, and this is a very good lesson. All these things are just so good lessons. There's no substitute in going through this where we have errors. So
hold on a minute, Thad. Let me see if this might work.
Okay, well, I have it ready to go if you want, but I'll wait, because it'd be better if obviously if you could do it. But one of the things, Stephanie, I anticipated in advance so that we have some redundancy here. If you can't actually co-host with somebody, you actually should have someone else at least able to help you remotely. And so the idea would be now that I should be able to run this PowerPoint presentation for Stephanie here. And it's the same thing in a deposition where she's hundreds of miles away from where I am. And if she has troubles with some exhibits, as her partner in the litigation, I should be prepared to go ahead and take over the screen sharing of her exhibits, even though she's the one who's going to continue on with the witness. Stephanie, need me to do it?
No, it's up now. I just noticed the numbers were missing. Like,
okay.
I knew it. Okay, sorry guys. So as we talked about, there was a before an officer requirement in FRCP 28. So what does that mean in terms of remote depositions? Typically you have a court reporter there live swearing the witness with the witness. Thad and I have had cases where we do telephone depositions, and the opposing counsel objected if we didn't have the court reporter in the room with the witness. So, you know, rather than have the court reporter with me, I'm like, fine, give the court reporter to the witness. I don't care. They're going to be, you know, they can see the witness and swear the witness and do all that and not do it, you know, remotely. Some defense lawyers seem to be sticklers on stuff like that, but stuff that can obviously delay you, hinder you, wait for the plaintiff to die, basically type stuff, obstruct you any way they can. So the court has done away with or basically said before an officer, most of the courts have said before an officer means if all the participants can see and hear the person swearing the witness and they're on the same Zoom or other platform that you're using, that's sufficient to be to meet the before an officer requirement. So then we get to kind of the question, which I think a lot of lawyers are trying to move towards. And if you've done any Department of Labor cases or MSPB cases, there actually isn't a stenographer in the courtroom with you anymore. It's a digital recording. There's someone there pressing a button to start record, pressing a button to stop record. So you don't, in federal court, you still have the person there typing lots of times, but in these other proceedings, they're moving into digital recording. So then the question is, can I do that in my deposition versus having a stenographer there. And the weight of the case law seems to be that, you know, FRCP 30 allows any kind of recording that the plaintiff or defendant gives notice of, so that you have the right to make a digital recording instead of a stenographic recording. The issue then is, how do we meet the before an officer requirement? So I know Thad's going to talk about this a little more, because, for instance, the SoundCloud company has individuals they will put on the conference with you while they're recording, or offer someone to come swear the witness for you to meet that requirement. So it's something you still have to be aware of. Even if you can digitally record, how are you going to make sure that you satisfy FRCP 28? Now, if you're like me, you might have immediately thought, how can I game the system so that I get a live appearance with the witness and the other counsel's on video deposition? Can I be there with my client? And the courts are kind of coming down on the side of, if it's a remote deposition, everybody has to be remote. In learning res out of the Northern District of Illinois, which is where one of our cases is, the defense counsel was over 65, you know, in the group that's at risk for health issues related to COVID. And he said, I can't appear live. I've also got risk factors in my family. I don't want to appear live and then bring that home to my family. And the court found that was sufficient cause to prevent the plaintiff's counsel from going live as well. You know, the plaintiff's counsel argued, well, another lawyer can come represent him, but represent the witness. And the court said, no, this is the witness's lawyer, and this is who's all beefed up on the case, and blah, it would be very prohibitive to get someone else up to speed. So no, you don't get to go live and be with the witness while this person has to be on video. And then separately, in Sonre v. Romano out of the Southern District of New York, plaintiff tried to take an expert witness live, and the defendant moved for a protective order. And the court granted the protective order, said the health concerns were enough, video deposition was suitable alternative, and you're not going to go talk to a witness live solely based on the concerns of the expert witness's health as well. So, and then if there are a slew of cases, and if you need them, I'll share this presentation, and I have a paper on it as well, just basically saying this is the new normal. I mean, you've heard the new normal 1,000 times. I'm sure you don't want to hear it again, but remote depositions, remote preparation, this is how we're moving forward. Any suggestions that this is going to resolve soon, or the stay-at-home orders or spacing orders will end soon, that's just, the courts have said that's just speculative. And, you know, I looked up, in the most recent case I found was, again, out of the Northern District of Illinois, Valdivia, July 28th, 2020. In that case, the defense had suggested, let's revisit this in 6 months and we can take depositions then, because this will probably resolve. And the court said, there's no indication that this is going to resolve in 6 months. So get moving now. And off they go, I presume. Now, it's pretty clear that if you want to take a Zoom deposition, you can take your Zoom deposition. The courts, you've got the weight of authority of the courts behind you. Once you decide you're going to do that and get agreement or a court order on proceeding, you then need to consider, how are we going to proceed? One, what platform are we going to use? Zoom's been a favorite one, like Thad described, but courts have said, get agreement with the other side. Like, if you can't agree with the other side, then I'm going to decide for you. So, you know, there are various other options, but as far as I have heard, Zoom has the only breakout room option currently, which would be a good argument if you want Zoom and the other side doesn't, and they want something else, say, have you considered that you're going to want to talk to your witness in a private breakout room? You know, and go from there. But you may also want to get familiar with the other platforms as well. Appearances.
Steph,
Yeah.
let me just say that everybody is moving real quickly to catch up on this, and WebEx now has the breakout rooms, and so does Microsoft Teams, at least in a beta version. GoToMeeting, which is one of the biggest ones so far, they're announcing that they should be rolling it out soon. But this technology is changing very rapidly.
Okay, so I'm completely wrong on that, basically. I mean, that is a consideration. Is that why the court selected it as the platform moving forward, the breakout rooms, or is that just unrelated?
No, the breakout rooms are as you'll explain to people, it's an important feature to prevent undue influence, and they don't want people leaving the platform. So you go into a breakout room. They do not want you texting with each other on the phone. They don't want you getting on the phone with your client. There's just no policing it. It's the honor system, of course. We're lawyers, but the breakout rooms are one of those. No, and you weren't wrong. What I'm saying is this is changing by the week now. Who has what feature?
Okay. 2 appearances. So the INRI chicken broiler case said ideal is everyone who's participating appears on the screen. Typically, when we did video depositions in the past, we only recorded the deponent. So that's a change. You're going to have counsel's going to be recorded if you're recording the Zoom, the Zoom deposition. Both counsel, anyone else participating, and of course the deponent. So the ideal there, I had thought the ideal would be just the witness, but the courts have said they want everybody participating on the screen. You can talk to their side and maybe come out to an agreement on whatever you specifically want it to be, though. So then time limits, the courts basically recognize you're going to need a bit more time to do these. So Thad and I don't run up against our time limits for witnesses. It would be cost prohibitive if we took the 7.5 hours for every witness. But defense also often takes a 7.5 hour deposition of the plaintiff. So you need to work cooperatively as well, because you're going to need some more time to address documents, to get used to the platform. Any kind of the technological issues that I've had so far on this could come up during your deposition. So have some agreement. We might need to have, instead of an hour and a half, kind of talk that through, and you need to be a little bit flexible with the defendants as well on what they need for time of your plaintiff. Now, swearing the witness. So we kind of talked about that a little bit before. Some states have just simply suspended the need for in-person swearing. The federal courts have said as long as the person swearing the witness is on the same platform, then you're covered. Some states haven't addressed it. So if you're in state court, you need to kind of research the rules and make your arguments on that. Now, witness coaching. Obviously, that's going to be more difficult on a remote deposition to catch someone improperly coaching your witness. I mean, as some of you already know and have been using, there's a chat function to the Zoom. So I could technically be sending my witness chat messages, change that, change this, change that, as they're testifying. So there are a couple safeguards you may want to deploy when you're setting a remote deposition. The witness must sit, so many feet away from their laptop or the computer that they're using. If you note a long pause on the record and you're not recording, you can say, oh, there was a long pause, or they're consulting something, they appear to be reading something. But you want to also have a stipulation with the other side. We're not going to talk to the witness during their testimony improperly, only for discussing privilege issues. We're not going to email, we're not going to text, things like that. And then finally, recording. Your FRCP 30B3 allows for the recording of testimonial, both audio, visual, or stenographic means. That does not mean the defense counsel will readily agree that when you want to record. Thad and I, for 20 years, toted our little individual handheld camera into depositions and said, we're recording these. It's authorized by the federal rules. we're not hiring a videographer. That's thousands of dollars. We'll make the announcements going on the record, off the record, blah, 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 everything that's required in the video, whatever to make you comfortable, but this is happening. And so far I think we had one judge out of maybe 10 that said we couldn't do it that way. The others put some various stipulations on it, but we were successful with just using our own handheld camera. So when you want to record the deposition using your Zoom platform, put that in the notice, and deposition will be recorded by Zoom. It's up to the other side to then go seek a protective order to prevent you from doing that, but their chances of success are limited, given that you've got the weight of FRCP 30 on your hand. So, and the New World Order, obviously.
Yeah, and just let me say that the biggest grounds for obstructing you and being able to use this technology, the video technology during your own, is the failure to have given notice that you intended to do so in your notice of deposition. I can't emphasize that enough. Whatever you intend to technologically do, every last little thing, you need to specify that in your notice of deposition. And
then the Southern District of New York has put together a handy dandy stipulation as to how they suggest you conduct remote depositions. This is something you may want to model your own stipulations out based upon. You can add to it, you can enhance it, add whatever you think, whatever you can get the other side to agree with that's going to benefit you. But here's a model you can look at so you don't have to reinvent the wheel each time. Appearance rules. 1, the deponent, court reporter, and counsel shall all participate remotely and separately. So there addresses your issue of the counsel being live and in a remote deposition next to the witness when you cannot be or will not be. Each participant shall be visible to all the other participants at all times, and you can see why that would be a desirable rule. Make sure counsel's not, coaching them somehow. You can kind of watch for a little bit what they're doing. I think that's what that's intended to address. Okay, then you have specific prohibitions. So counsel's not to initiate private text, email, or the chat except for determining privilege. During breaks, however, as is typical in a live deposition, parties can use a breakout room feature and they will not be recorded. I mean, that would be pretty shady if you tried to record the counsel's communications with the witness if it was their own client. So obviously these are ethical rules that lawyers would follow anyways, but here you are. It's best to put it in a stipulation because this is something different that we're dealing with. Everybody has to agree to cooperate during remote depositions. 48 hours before, let's troubleshoot any issues we have. During the deposition, you can't just, having a stipulation like this will ensure the party doesn't say, oh, the line cut off, I just walked out with my witness, we're done, that kind of thing. So addressing that beforehand will kind of protect you against errors and willful walkouts like that. Okay, then you've got some equipment rules. The deponent has to have sufficient webcam, computer, audio, and bandwidth. If it's your client, you need to make sure they have that technology. And if not, you need to figure out a way that they get it. If it's a third-party deponent and you're taking the deposition, the burden's on you to ensure the deponent has the technology. And if they don't have it, you've got to find a way to provide it for them. If you're deposing a defense witness, defense counsel has to take care of ensuring that the party has the required technology for proceeding.
And just to note, the one judge in the Southern District of New York has said that this means that if there is a deponent and the deponent doesn't have any of this equipment, you will provide all this equipment to the deponent. How it doesn't go into how you'll do that, whether you'll send it by UPS or whatever, but you are going to provide the equipment. You're going to provide the Wi-Fi. Maybe you'll have to pay for them to go somewhere else. I don't know, but the courts you are going to solve the problem. So if we are taking the corporation's senior vice president, the corporation is going to do this. We're going to do the same thing for our whistleblower clients. And if we are subpoenaing a non-party deponent. In our case against JP Morgan, just degenerated into deposition of all these clients and former clients. I mean, scores of them were being looked at, and we were having to do these. And these were retired people. One of them was like living in a nursing home, right, Stephanie?
Yeah, they couldn't actually take her deposition because the COVID nursing home prohibitions had already come down. So that was the reason they got
right. But now our obligation would be for someone who doesn't know the first thing about this technology, it will be our obligation to make it happen.
Well, my favorite part about that is that defense counsel noticed all those depositions. So they've got some of these people, one person like passed out and fell down during our deposition. So that was pretty sad and scary, but the defense counsel, having noticed those, is going to have the responsibility for making sure all those people can get on Zoom. I'm not sure how, but that's going to be, you can't bring in an elderly person in this day and age and depose them live. So, and now the exhibit methods, all of these are geared towards, obviously, although Thad does it, because he's so confident in his depositions, he puts exhibits down in front of the witness in advance and tells them, read as much as you want. I'm, of course, very secretive with my exhibits. I want to surprise them. So you have an exhibit 1 method. If you're sending paper exhibits to the witness, they have to leave them sealed until they open them on the record. So there's going to be exactly the exhibits that you presented to them in the order you wanted them presented. You can send them electronically with a password, and then you provide the password at the start of the deposition for them to open. Or you can, as you get more comfortable with Zoom, as Thad's making sure we're all more comfortable with Zoom, you can do your exhibits as you're taking the deposition, like you would live, so that you can just start with the screen share and say, okay, take a look at this exhibit. That's probably the method that I will use, largely because my exhibits are not ready that far in advance to mail them, certainly not. And I like the element of surprise, and Jack can speak more to that in terms of what he did with exhibits. So basically, to sum it up, it's time to get going on Zoom depositions. You're going to win if somebody tries to stop you, and get trained on it. We've already been talking to our clients via Zoom, practicing with them on Zoom, doing settlement conferences on Zoom. So we're getting everybody up to speed, kind of ready to address this. Thank you.
Thank you very much, Stephanie. That was just absolutely spectacular.